Hi, so thank you everyone for joining us this afternoon on an important and particularly relevant topic today and likely for the foreseeable future, COVID-19 guidance for government contractors. With me today is my colleague Lauren Brier, who works out of our DC office. I'm in Colorado and I manage our Boulder office out here. A little bit about our firm. PilieroMazza is a business law firm dedicated to servicing the needs of federal contractors and commercial businesses. We provide services in the areas of corporate law, labor and employment, and litigation. But what we are most well known for is government contracting. I mean, we have a pretty deep bench of experienced government contracts lawyers, and it's the practice area in which Lauren and I primarily work. So just a little overview about what we're going to be talking today. Federal guidance on contract issues associated with COVID-19 and types of federal relief that's available. Stop work orders, suspensions, and terminations in the context of COVID-19. Bases for submitting REAs and filing claims stemming from COVID-19. And lastly, planning for the future, meaning how to protect your existing contracts during the pandemic. And just so you know, you do have the ability to submit questions through the chat option. I think in the interest of time, please submit them. And then after the webinar, either Lauren or I will reach out to you directly and address your question. So recognizing that federal contractors play a vital role in helping agencies meet the needs of US citizens, including response efforts to COVID-19, in March of this year, the Office of Management and Budget, OMB, issued a memorandum identifying steps to help ensure the safety of federal contractors while continuing contract performance. According to OMB, agencies should maximize the use of telework instead of discouraging it, to include modifying contracts that do not currently allow for telework. They also encouraged agencies to extend or alter contracts if contractor personnel must be quarantined, noting specifically that government contracts provide for excusable delays, which may extend to quarantine restrictions due to COVID-19 exposure. Agencies can reprocure if necessary, but they should be as flexible as possible in finding a solution for the contractor if, for example, employees are unable to telework. With respect to REAs, they should be considered on a case-by-case basis, taking into account whether the requested cost would be allowable and reasonable to protect the health and safety of contract employees. For example, did the contractor take actions consistent with CDC guidance? Did the contractor reach out to the CO to discuss appropriate actions? And agencies could also consider whether it's beneficial, for example, to keep key personnel in a mobile ready state for activities deemed critical to national security or other high priorities. Whether work on federal buildings such as museums should continue or stop also needs to be addressed on a case-by-case basis, and agencies should look to CDC guidance to determine if there's a risk-based reason to stop work. The memo from OMB also advised agencies that for procurement-related activities that would normally incur in person, such as proposal preparations, presentations and debriefings, that they should follow CDC recommendations and consider conducting them virtually as opposed to in person. And then finally, the memo emphasized how clear and timely communication between agencies and industry partners was going to be critical to the government's response to the pandemic. As it pertains to the FAR, the second part of FAR Part 18 describes additional acquisition flexibilities that become available when there's an emergency declaration or a major disaster declaration. The FAR defines those declarations as declarations by the President pursuant to the Stafford Act, and in March, the President issued such a declaration. In doing so, he triggered the availability of a few provisions that are particularly relevant to COVID-19 contractors. For example, it raised the simplified acquisition limit to $750,000 for domestic procurements and $1.5 million for OCONUS acquisitions. It also raised the micro purchase threshold from 10,000 to 13,000 for domestic purchases and 30,000 for OCONUS purchases. So another avenue for federal contractors to potentially secure relief from the impacts of COVID-19 on their business operations is under 3610 of the CARES Act, Section 3610. Under certain circumstances, Section 3610 permits agencies to reimburse federal contractors employee compensation. More specifically, for federal contractors confronted with the inability of their employees or subcontractors to perform work at a federal work site and whose job duties cannot be done remotely through telework, Section 3610 provides federal agencies with the discretion to reimburse these contractors at the minimum applicable contract billing rates for any paid leave, including sick leave provided to employees or subcontractors, with the idea being to keep them in a quote unquote ready state. The amount reimbursed and at what level, that's at the discretion of the CO. So what steps can contractors take in connection with Section 3610? There's a number. I mean, first and foremost, you should be contacting your contracting officer to discuss whether reimbursement under Section 3610 is available. Discuss with the contracting officer the specific agency implementation guidance in connection with 3610. Obviously, document any claimed leave cost for employees and subcontractors, and segregating those amounts intended for reimbursement under Section 3610. Similarly, document all relief and credits received from other programs under the Families First Act or the CARES Act, for example, the Paycheck Protection Program. And finally, that just remember that reimbursement is not mandatory under Section 3610. Rather, it's at each agency's discretion. So contractors should nevertheless avail themselves of all opportunities to obtain amounts where appropriate.
So as Peter has indicated, most recently, various agencies have issued guidance to its contracting officers on the handling of COVID-19 and its impact on current and future contracts. Another agency that we felt was important to mention is the Department of Defense. On March 30th, 2020, the Office of Secretary of Defense issued its own memorandum for managing defense contracts and the impacts of the coronavirus. On a high level, the memorandum discusses the challenges that the Department of Defense is facing in response to COVID-19 and the fact that it's impacting DoD's military, civilian, and defense industrial-based communities. The memo also recognizes that COVID-19 will impact the cost, schedule, and performance of many DoD contracts. For example, the memo itself notes that many contractors may experience issues of unavailability or experience movement restrictions on base for their personnel. One thing that's also important to take note of is that the memo specifically states that the Department of Defense must do their utmost to ensure that both the department and the vital industrial base that support the department remain healthy the duration of this emergency and emerge as strong as ever from the challenges of the pandemic. This is important language that we believe could be implemented into something like a request for equitable adjustment or negotiations with the contracting officer to reinforce the importance of keeping contractor personnel and DoD personnel healthy as performance moves forward on the contract. More specifically, the guidance cites the clauses in DoD contracts that would be helpful to a contractor when negotiating equitable adjustments or changes to the contract. Importantly, the memo says that such requests or changes would not impact a contractor's performance ratings in the CPAR system. Some of the clauses that the memorandum itself recognizes are like the excusable delay clause, which is FAR 52.249-14, the various termination clauses like termination for convenience clauses, and FAR 52.212-4, which is a common clause incorporating commercial contracts. The memo also indicates, and I think Peter made reference to this in the OMB guidance, that issues relative to COVID-19 are going to be reviewed by contracting officers on a case-by-case basis, as every contract is different and every issue faced by a contractor will be different as well. Another important thing to consider is that costs tied to any changes stemming from COVID-19 that are presented to the contracting officer will still need to satisfy cost accounting standards, meaning contracting officers will have to take into account whether the costs would be allowable and reasonable to protect the health and safety of employees. So GSA is another agency that's also come out with related guidance for contracting officers specifically, as well as contractors. For existing contracts, GSA is really pushing their contracting officers to get the ball rolling as far as negotiations with contractors to determine whether there's a potential impact from COVID-19 and whether or not services that are being provided can be performed on site and are mission critical, or if they can be performed off site or through telework processes. They're really pushing their contracting officers to have these discussions early on so as to avoid potential hiccups down the line. They are also being pushed to identify potential alternate sources of supply and product substitutions, and to communicate with their most key customers to keep informed of any issues that could pop up as performance continues. If a contractor is actively performing and are currently experiencing COVID-19 issues related to a GSA contract or foresee problems down the line, based off of the guidance that they're presenting to their contracting officers, we recommend as a diligent practice to reach out to your CEO as soon as possible to discuss any issues that you could foresee as the pandemic unfortunately continues. GSA also came out more recently with new guidance that outlines how it's changing the process for onboarding and offboarding contractors in light of the pandemic and remote working. This guidance can be found online pretty easily, but one of the things that we felt like highlighting was for contractors who are now working remotely, GSA will not be providing laptops or other government IT equipment because of limited supplies that they currently have. Another thing to take note of is that for contractors who are required to access GSA networks, they are now being required to submit requests to activate access to such networks.
So moving on to COVID-related stop work, suspension orders, and terminations. So stop work orders, there's the FAR provision where you can find it. In some cases, it might be appropriate to stop work while quarantines or social distancing requirements are in effect, especially for contracts that require interaction with the public. And in those situations, the stop work FAR clause may provide protection, although for both a schedule, allowing for both a schedule adjustment and compensation for costs associated with performance delays if the contracting officer, and importantly, in his or her discretion, issues a stop work order. Stop work orders, they have to be sent by writing or in writing to the contractor. They can come via email, they can come via a formal letter, but notably upon receipt of a stop work order, a contractor must take immediate and reasonable steps to mitigate any additional cost incurred on the project. So for example, this might include moving workers to different projects or using equipment at other project locations. Keeping detailed records of any extra performance cost incurred as a result of a work stoppage is critical if a contractor intends to submit those costs to the government through a claim or through an REA. And to pursue schedule and compensation adjustment in the circumstances, a contractor would need to assert its rights under this clause within 30 days after the end of the period of work stoppage, which is important to remember. The FAR also permits the CO to temporarily suspend performance in the best interest of the government. The suspension of work clause in the FAR provides for an adjustment of the contract price in the event that the work is unreasonably delayed. And that unreasonably delayed has to be by an act of the contracting officer in administrating the contract or by the contracting officer's failure to act within the time specified in this contract or in that contract. And this language has been interpreted to permit contractors to recover additional costs in a number of circumstances, including as a result of delays that are caused by government restrictions on access to the worksite. But I mean, as you can imagine, though, it is more difficult to recover costs if work is suspended during the pandemic, because you need to make a connection between a COVID-19 related suspension and the conduct of the contracting officer. So it's difficult, but it's something that you can still try. You essentially need to convince the agency that the suspension is coming from them, even though it's related to COVID-19. And Lauren and I were talking about this morning. And the one example situation, whatever you want to call it, that we came up with, where you might have a decent argument that you were entitled to cost recovery, if the site was shut down because of an outbreak, and that outbreak was caused by the contracting officer not following CDC guidelines. In that situation, you're essentially tying the contracting officer conduct and not following the guidelines to the shutdown itself. But generally speaking, it's not going to be easy to get costs. I mean, you may get additional time, but getting money is going to be difficult. To the extent that a contract is terminated in whole or in part as a result of COVID-19 related restrictions, contractors will be entitled to recover certain costs under the standard FAR termination for convenience clause, which is 52.4249. Termination convenience settlement proposals must be submitted in accordance with the FAR Part 49. And the FAR sets forth detailed rules regarding the categories of costs that are recoverable in the event of a termination for convenience. But there often are nuances in the application of these rules to the particular facts of the case. FAR 49602 prescribes a particular form that settlement proposals must be submitted on. And then importantly, in terms of, because we work with a number of, we often work with clients in helping them prepare settlement proposals when their contract has been terminated for convenience, and the fees that they incur for our legal services, those are recoverable.
So moving on to, oh, sorry, go ahead, Peter.
I was going to say exactly what you were going to say. Go ahead.
Oh, okay. So moving to bases for REAs and claims arising from COVID-19, we wanted to cover some of the more common claims and REAs that we've been currently filing for our clients relative to the pandemic. The first clause that has been highly relevant to the REAs and claims that we've been filing is the excusable delay clause. And the most commonly used version of that is FAR 52.249-14. And under the standard clause, contractors are excused for delays that affect the contractor's ability to timely perform, so long as the delay is beyond the control and not due to the fault or negligence of the contractor. The excusable delay must be unforeseeable and arise from things such as acts of the government or unusually severe weather, or in this case, a pandemic that was unforeseen. More of the delay must be to the critical path of performance, having an impact on the contractor's actual ability to complete performance in the period called for by the contract. When a contractor is able to demonstrate excusable delay, most commonly it's entitled to an extension of time for performance, but not an increase in cost. And this issue relates back to what Peter previously discussed. In order to receive costs on an excusable delay claim, the delay has to commonly be connected to government conduct. Here, we're seeing a lot of pushback from contracting officers as far as deeming COVID-19 related delays as government within the government's control. So one of the distinctions is whether or not a delay claim is a compensable delay claim or a non-compensable delay claim. So Common non-compensable delay claims are often unrelated to government conduct. So in this case, it would be like a strike, weather, acts of God, fires, floods, etc., which commonly incorporates spread of disease or pandemics. And again, like Peter said, it would entitle the contractor to a time extension, but not necessarily cost. Compensable delays are same as excusable delays in the sense that they're unforeseeable and beyond the contractor's control. But again, these delays are normally caused by the government, which would entitle you to cost. If the delay was the fault of the government, the contractor gets compensated for the costs associated directly with the delay. Most common types of compensable delay claims are where the government does something during the performance period that directly interferes with performance production. So basically that example that Peter provided earlier is really great as far as showing where the government may have a direct impact on the delay. Another good example is where the government would prevent base access to allow you to construct a building due to a personnel outbreak, and the lack of government safety procedures in place, were the cause of that outbreak. So I think there you could really connect that the outbreak was within the government's control and could argue for cost and an extension of time caused by the shutdown. An example where it could go both ways, which we are often seeing in the claims and REAs that we're filing, would be where, say, a contractor is performing in a COVID-19 hotspot. The contractor originally said you could work 24 hours a day on a project with a team of 5 and could excavate around the clock. All of a sudden, the hotspot gets worse and the government says, we're no longer going to let you perform 24 hours a day around the clock. You can only work 3 hours a day with a team of 2 to prevent a COVID-19 spread. So how would you be able to, recover the time of delay and then any cost, i.e., renting excavation equipment for an extended period of time? What we would want to do is put forward a claim, that covers both delay and the cost, and try to connect the government's conduct to the stoppage or restriction of time allowed on site. Again, the government is likely to push back, saying that we would be entitled to an extension of time, but the cost would be outside of their control. But again, it's definitely worth arguing for recovery of both. However, cost recovery is likely not to be automatic in a circumstance like that. Another avenue for recovering costs related to COVID-19 would be filing an REA or claim relative to the changes clause in your contract. The changes clause is often cited as FAR 52.243-1 in fixed price contracts. This change clause allows for an adjustment in the contract price when changes are made to the scope of work, either through formal written order or conduct. So if COVID-19 is having a significant impact on the scope of performance, it's often recommended that you go to your contracting officer as soon as possible to request a formal order to increase costs or extend your time of performance. Change clauses often require contractors to provide 30 days from a directed change. So if you believe the government has made a change to your contract based off of a COVID-19 related issue, it's pertinent that you provide immediate notice to the government of your intention to file an REA or claim that's relative to that change. A good example of this would be, say you have a food services contract and the government directs that all contractor personnel start wearing special PPE, including masks and gloves, when serving food that were previously not required in your scope of work. So all of a sudden your costs are significantly increased due to the special PPE and masks and gloves that you're now purchasing to perform the work. The costs that have increased as a result of this change could be recoverable under an REA or claim once filed with the contracting officer. demanding entitlement to recovery of costs as a result of the enlargement of these performance requirements. So that's a good example of how you could potentially recover costs under the changes clause. Another issue that we are seeing amongst our clients as far as changes or delays caused by COVID-19 is negotiations between government personnel on COVID-19 related issues. So when you're discussing COVID-19 issues with government personnel and any potential changes to the contract or delays caused therefrom, it's really important that any direction that you're receiving from the government concerning these changes or issues are coming directly from the contracting officer or formally designated representative. If, for example, a contract specialist on site is demanding a site closure due to COVID-19 or is in some way attempting to change the contract as a result of the pandemic, it's really important to confirm that such changes or directions with the contracting officer before taking any action or agreeing to any change in your scope of work or performance. The same recommendation goes with any modifications issued or requests for changes in performance periods due to COVID-19. It's always important to make sure that these changes are coming from the top of the contracting chain. We've had issues with clients receiving requests to extend contracts relative to COVID-19 impacts, but requests are coming from, managers or engineers on site. Although it took days, at times to negotiate any extensions in performance, it's really important that the extensions are coming from the top, from the CEO, before you're agreeing to make any changes or let personnel go. Otherwise, the contractor or our clients are often left holding the bag and finding out that their performance period is much shorter than they had initially anticipated based off of conversations they had with people on site that really had no contracting authority to make those decisions. Another thing to keep in mind when you're entering into negotiations with government personnel, specifically contracting officers on COVID-19 related issues, in every federal government contract with the contractor, there's an implied covenant of good faith and fair dealing, which is a common law principle that suggests that every contract imposes upon each party a duty to cooperate in good faith and deal with each other fairly. The legal doctrine applies to both commercial contracts as well as federal government contracts and is recognized both by the Board of Contract Appeals and the Court of Federal Claims. They both have held that each contracting party to a federal government contract has an affirmative legal obligation not to hinder performance or prevent the other party from obtaining the fruits of their bargain. So a good example is when the government does something that's on its face may suggest like underhanded activities or refuses to acknowledge issues related to COVID-19 and its direct impact on your personnel or performance. This could plausibly give rise to a breach of good faith and fair dealing. Another example would be if the government, say, is refusing to shut down the site due to an outbreak and demanding continued performance, or they may not be communicating with the contractor in a timely manner about safety procedure requirements on site. A contractor may have a claim or an REA or argument to make that the government is failing to cooperate and causing an undue delay in performance or an unsafe environment. So this is something, to keep in back of your mind as you engage in discussions or negotiations with contracting officers relative to COVID-19 issues. Another thing that's really important to consider when discussing COVID-19 related issues or engaging in negotiations with contracting officers on any delays stemming therefrom are waivers and reservation of rights language. We are constantly telling our clients to be weary of, such language before signing any type of modification to a contract that may be related to COVID-19. We have been seeing the government issuing modifications to extend performance while also asking contractors to release their right to cost related to that extension. So if you believe that, you're entitled to COVID-19 related costs, you want to make sure that you're reserving your rights to those costs if you are executing a modification and extension of performance. An executed bilateral modification that contains no reservations can constitute as an accord and satisfaction and basically wipe away any right you may have to COVID-19 costs that were incurred prior to your execution of the modification. If the release language in a modification is unambiguous, you're pretty much stuck with the plain and ordinary meaning of the release. So our best advice is if you think there's a possibility of a claim or REA related to COVID-19 issues, you want to make sure to reserve your rights directly in the mod by implementing language that says directly that. Under the Contracts Dispute Act, you have 6 years to file a certified claim with the CO for costs. So it's really important that you protect your rights to do so before signing any type of release or waiver of rights in a modification or contract with the government. Finally, as far as REAs and claims go and things to take note of, one of the things we often recommend to our clients is also the use of experts and consultants and how helpful they can be in submitting an REA or a claim with a contracting officer. Because a claimed amount specifically must be calculated based on reliable principles and accounting methods, if your claim exceeds the $100,000 threshold, which requires a claim to be certified, we often recommend that a cost accountant or cost consultant or expert be brought in to evaluate, the calculation of costs or delay damages, as we find that is often makes it easier in negotiations with the contracting officer if we have a consultant report breaking down justification for our cost request and recovery. Another good use of an expert would be if we were dealing with an extension of time request. Sometimes we're seeing, like for instance, the Army Corps of Engineers often ask for what's called a time impact analysis. Oftentimes we recommend that contractors get an independent third-party scheduling consultant to provide a detailed time impact analysis in support of a request or a claim. Oftentimes this just saves time on the back end for the contracting officer to review the claim and make a decision. And one of the other benefits is that expert and consultant costs in an REA can be enveloped into your request for recovery and compensable by the government.
Planning for future contracting amidst the pandemic. So how do you protect yourself on your existing contracts during the COVID-19 pandemic? First and foremost, and this goes without saying, review your contract. For example, does it allow for teleworking? And if not, consider asking the CO for a contract mod so that employees can telework if at all possible. Focus on the welfare of your employees, keeping in mind that your employees are your biggest asset. So make sure that they are comfortable working on site or teleworking, because if they're not, you're likely going to encounter performance issues. And document and communicate, meaning keep detailed information of how COVID-19 is impacting your business. And if you encounter unknown costs or delays, bring them to the CEO's attention as soon as possible. And finally, have open communications regarding issues encountered. Not only with the government, but with the prime contractor, subcontractor, and even lower tier subs if applicable. And then finally, why do you want to keep doing business with the federal government amidst the pandemic? As you can see, there are a number of reasons why listed on this slide, but I will tell you that, and I think Lauren would say the same, that most of our federal contract clients have fared pretty well over the course of the past several months, at least in terms of continuing work. Many of them have not experienced any stoppage of work, meaning businesses as usual. Employees are getting paid and the doors remain open. And for those who have been negatively impacted by the pandemic, we have worked with them to obtain federal relief under the CARES Act. So I guess in sum, I mean, frankly, all things considered, it's not a bad time to be working in the federal contracting arena. And with that, again, if you have any questions, you can feel free to submit them. It looks like we've gotten a few through the chat. Feel free to reach out to me or Lauren. Our email addresses are obviously right below our names here. But again, thank you all. And I hope you found this to be an informative webinar. And again, if you have any questions, send them our way.